traditionally, when you are a party before the court, you cannot on your own embark on execution exercise. Executions of the court orders and processes are exclusive functions of the court bailiffs, court sheriffs, and judicial processes, and not in any way exclusive reserves and prerogatives of a party to the litigation. So what happened by way of forceful eviction of my family members, forceful taking over of my properties, and forceful perhaps invasion of these properties of mine is legally and judiciously unprecedented in the Nigerian history and Nigerian legal system. It has never been a tradition of perhaps relying by an institution for establishment of government on interim orders of forfeiture to force an eviction onto a co-litigant before a court of law. So my take is what is unfolding on the part of EFCC is indeed steps that are extrajudicial, that are unprecedented, that are unlawful, that are illegitimate, and that are now intended apparently to cause a situation of helplessness on the part of the court, which had already fixed the hearing of the application relating to these properties to a certain date, which is fixed for 20th day of April 2026. So I think it is on this basis that it is important for me to put across the situation that is unfolding.
This one, they attempt to, of course, seal your apartments within Abuja. We want to find out what is really the situation, because we get to say there was an order which is no more valid. What's the situation now?
Well, the incident that happened yesterday was not isolated one. It was further confounded by additional unfolding events this morning. There was an attempt yesterday by the EFCC, which indeed was a co-litigant in respect of the pending criminal proceedings before Federal High Court against my person. Arising from that criminal proceeding, there was an order dated 6th day of January 2026, an interim order for forfeiture that was granted. The most interesting part of the order, there was no clear directives or instructions in the order that the premises will be taken over forthwith, or perhaps being sold, or perhaps evicting the occupants of the respective premises. But the most interesting part of it is an application was filed at my instance for setting aside the order. And the court fixed a date against the 20th day of April 2026 for the hearing of an application filed at my instance challenging the propriety or otherwise of the order. Conventionally and traditionally, by the act of securing the order by the EFCC and by the act of veiling issues on my part by way of filing an application seeking for the court order to set aside, issues are joined by the parties. So it is only natural, logical, legal and judicial that no party is expected to overreach by way of taking unilateral steps that will place a court in a situation of helplessness. But unfortunately yesterday, without further request to the court, without seeking for an order to seal my properties, without seeking for an order to evict me and my family members from the property, without seeking a court order for the appointment of receiver manager, the EFCC came yesterday to effect forceful eviction. They were unable to conclude on the process yesterday and reinforced this morning with a lot of personnel that are armed and indeed forcefully take over possession of my family residence and the family members who are equally taken out of possession. It is commonplace and it is in line with the tradition of the judicial process that when a matter is pending before a court, you cannot unilaterally act as a party to take steps or perhaps to take steps that will render the court